Hello and welcome to Indepth. I'm your host Aditi Nagpal Girotra. 2 weeks ago, the International Court of Justice ordered Pakistan to grant consular access to Indian national Kulbhushan Jadhav. Finally, on Thursday, Islamabad announced that it was ready to comply with the ICJ order. India has once again reminded Pakistan that the consular access that it intends to provide Jadhav should be done in an environment that is free from the fear of intimidation. The term consular access refers to a basic right of anyone who is arrested or detained in a foreign country. It implies that the embassy or consulate of that person's country of origin is notified of the arrest. Consulate officials can then check up on the arrested persons and provide them the necessary assistance. Today, in depth, we look at this issue in detail and answer why it has become so important in the Jadhav case. We also look at the times when individuals have been denied this basic right and what the world community did about the issue. India has demanded unimpeded consular access to Kulbhushan Jadhav in an environment free from the fear of intimidation, in sync with the ruling by the International Court of Justice. India's reaction comes a day after Pakistan offered consular access to Jadhav on Friday at 3:30 p.m. Take a look at all the details in our first report.
Responding to Pakistan's proposal offering consular access to Kulbhushan Jadhav, India demanded unimpeded consular access to Jadhav in an environment free from the fear of intimidation and reprisal in accordance with the ruling by the International Court of Justice. India's response came a day after Pakistan sent a proposal on August 1st offering consular access to Jadhav but with some conditions. One of the conditions reportedly was the presence of a Pakistani official during the meeting between Jadhav and Indian officials. Pakistan's offer comes 2 weeks after the ICJ ordered the country to carry out a review and reconsideration of Jadhav's conviction and sentencing, and also to grant consular access to India without further delay.
We have received a proposal from Pakistan. We are at this point of time evaluating the proposal in the light of the judgment of the International Court of Justice. We will maintain communication with Pakistan in this matter through diplomatic channels.
So India has again requested for consular access. This will be about the 18th time, and now Pakistan has agreed to provide conditional consular access to Kulbhushan Jadhav to the Indian authorities.
India is seeking consular access in Jadhav's case as per Article 36 of the Vienna Convention, which states that foreign nationals arrested or detained should be given notice without delay of their right to have their embassy or consulate notified of that arrest. If the detained foreign national so requests, the police must fax that notice to the embassy or consulate, which can then check up on the person. The notice to the consulate must give the person's name, the place of arrest, and if possible, something about the reason for the arrest or detention.
The High Commission in Pakistan India's High Commission in Pakistan has to look after the interest of all Indians within that state, subject to international laws. Now, in this particular case, when Kulbhushan Jadhav was arrested, he should have been provided with this access of our diplomats who are based in Pakistan as part of the High Commission. They are our consuls there.
You know what the Pakistan government tells us is that he was arrested on the 3rd of March 2016, and then we were informed on the 25th of March 2016, but after that we have been asking for consular access for our officials to go and meet him and to inquire about his welfare, about what are the charges for which he is being arrested, but that access was not made available to us.
49-year-old Jadhav, a retired Indian Navy officer, was sentenced to death by a Pakistani military court on charges of espionage and terrorism in April 2017 following which India moved the International Court of Justice. Following the ICJ order, India asked Pakistan to grant full consular access to Jadhav at the earliest in full compliance and conformity of the World Court's verdict. In its 42-page order, the court, while rejecting Pakistan's objection to admissibility of the Indian application in the case, held that a continued stay of execution constitutes an indispensable condition for the effective review of Jadhav's sentence. The bench, however, rejected some remedies sought by India, including annulment of the military court's decision convicting Jadhav, his release, and safe passage to India. However, the ICJ upheld India's stand that Pakistan is in gross violation of the Vienna Convention on Consular Relations of 1963 on several counts in the case. With Leena Sharma, Bureau Report, Rajya Sabha Television.
India has demanded consular access to Kulbhushan Jadhav under the rules of the Vienna Convention on Consular Relations of 1963. This is an international treaty that defines consular relations between independent nations. A consul who is not a diplomat is a representative of a foreign state in a country and works for the interest of his countrymen in the host country. Let's now understand what the convention rules specify in such case.
The Vienna Convention on Consular Relations of 1963 is an international treaty that defines a framework for consular relations between independent nations. The treaty provides for consular immunity and has been ratified by 180 states. A consul generally operates out of an embassy in another country and performs two functions: protecting the interests of their countrymen in the host country and furthering commercial and economic relations between the two states. The convention was adopted in Vienna on April 24, 1963 at the United Nations Conference on Consular Relations. The treaty contains 79 articles, with the preamble stating that customary international law will apply to matters not addressed in the convention.
There are various aspects when countries deal with each other. And when they agree to have consular relations, that means they agree to deal with each other. It is a mutual agreement. Now, the receiving country A has sent its consul to country B. That means this consul, which has sent its representative to another country, it is there to protect the interests of that country, commercial, security, and all other interests. It is also there to protect the interests of individuals and individual corporate bodies. Now, this has been given out in the Geneva Conventions. In case of individuals, wherever they require legal assistance, if they are to be prosecuted or for any other reason, then they have to be provided consular access.
It provides the country to which this individual belongs to inquire from her or from him as to what is his condition, is he in good health, is he being taken good care of, inquire from him that he is not being tortured, inquire from him as to what are the crimes or what are the charges under which he has been arrested, and to mount a case, a legal case for his defense, for his so that he can be acquitted, he can be released, or see what are the way forward.
Of some of the significant provisions in the Vienna Convention, Article 5 lists 13 functions of a consul, including protecting in the receiving states the interests of the sending state and of its nationals within the limits permitted by international law. Article 23 provides that the host nation may at any time and for any reason declare a particular member of the consular staff to be persona non grata. The sending state must then recall this person within a reasonable period of time. Article 31 provides that the consular premises are inviolable by the host nation. Article 35 provides that freedom of communication between the consul and their home country must be preserved. The convention provides that consular officers must have access to nationals of the sending state. Article 37 provides that the host country must immediately notify consular officers if one of the sending state's nationals dies or has a guardian or trustee appointed over them. Article 40 provides that the host state shall treat consular officers with due respect and take all appropriate steps to prevent any attack on their person, freedom, or dignity. Article 43 provides for consular immunity. Consular immunity is a lesser form of diplomatic immunity. Consular officers and consular employees have functional immunity, which means immunity from the jurisdiction of the host state in respect of acts performed in exercise of consular function, but do not enjoy the broader personal immunity accorded to diplomats. Articles 58 to 68 deal with honorary consular officers and their powers and functions.
The aspect of consular access is that when a person, a foreign person in another country gets arrested because of some crime or something, then the government, the country in which he or she has been arrested, they are required to notify the country where the person belongs, and then they are required by the Vienna Convention to provide access to this arrested person to the officials of the country from which he comes.
The host country, they can give and they can speak to their personnel who have been so detained, provide whatever assistance is required in consonance with international law. That is what the advantage is. Basically, we are looking at a situation where there is no arbitrary functioning.
Consular access to Kulbhushan Jadhav means that Jadhav's own views about the entire case might get heard. Jadhav's video confession was extracted by Pakistan under force. That's one of the biggest reasons that India wants consular access to him. With inputs from Leena Sharma, Bureau Report, Rajya Sabha TV.
With this, we'll halt in for a short break on In-Depth, but we'll be back soon. Stay tuned with us. Welcome back. You're still with us on In-Depth. I'm your host, Aditi. India and Pakistan have for 2 years stood their ground with regard to the Kulbhushan Jadhav case in the International Court of Justice. Here's an in-depth look into the Jadhav case from the day he got arrested till now.
On 3rd March 2016, former Indian naval officer Kulbhushan Jadhav was arrested reportedly from Balochistan after he entered from Iran. Few days later, Pakistan released a video of Jadhav purportedly confessing of being an Indian spy. According to the Pakistani law, Jadhav was found guilty of espionage under Section 59 of Pakistan Army Act 1952 and Section 3 of Official Secrets Act of 1923. On March 26, 2016, the Indian government claimed there was no proof that Jadhav, who owns a cargo business in Iran, was arrested in Balochistan. Then, on March 29th same year, India sought of consular access to Jadhav from Pakistan. Over the next 1 year, India made 16 such requests that were denied by Pakistan. Next year, on April 10, 2017, a Pakistani army court sentenced Kulbhushan Jadhav to death for his involvement in espionage and sabotage of activities against Pakistan. India warned Islamabad that it is a case of premeditated murder. External Affairs Minister Sushma Swaraj asserted in both the Houses of Parliament that India will go out of way to ensure justice to Jadhav, who is an innocent kidnapped Indian. India also demanded from Pakistan a certified copy of the charge sheet as well as the judgment in the death sentence of Kulbhushan Jadhav and sought again for consular access to him. India officially seeks from Pakistan details of the trial proceedings against Kulbhushan Jadhav as well as the appeal process in the case. External Affairs Minister Sushma Swaraj then wrote to the then Pakistan Foreign Affairs Advisor Sartaj Aziz requesting visa for Jadhav's family. After failed attempts, India approached the International Court of Justice at Hague against Pakistan military court's decision. On May 9, 2017, ICJ stayed Jadhav's execution. Both India and Pakistan remained at the crossroads as New Delhi demanded the immediate suspension of Jadhav's death sentence, while Islamabad accused India of using world body as a stage for political theatre through a misconceived plea. However, a 10-member bench of the ICJ on May 18, 2017 restrained Pakistan from executing Jadhav till adjudication of the case. Pakistan, however, said that the ruling by the ICJ did not change the status of the case, even as the opposition party leaders attacked the government's handling of the matter at The Hague. 10 days after the ICJ's order, Pakistan claimed to have fresh evidence against Indian national Kulbhushan Jadhav. On June 22, 2017, the Pakistani military announced that Kulbhushan Jadhav had filed a mercy petition with Army Chief General Qamar Javed Bajwa. Jadhav filed the mercy plea with a confessional statement that he was involved in subversive activities in Balochistan. Pakistan yet again rejected India's request for consular access to Kulbhushan Jadhav when both the countries were scheduled to exchange lists of prisoners under a 2008 agreement. On July 13, 2017, Pakistan said it was studying a visa application of the mother of Kulbhushan Jadhav to meet him. India had requested Pakistan to allow Avantika Jadhav to meet her son. But the Ministry of External Affairs said India had not got any information on change in visa and consular position in the Jadhav case. In October 2017, Pakistan started the process to file its plea in response to India's representation submitted in the International Court of Justice against the death sentence of Jadhav. The ICJ had asked Pakistan to submit its written response or memorial by December 13th before the court could start further proceedings. A small breakthrough came on November 10, 2017, when Pakistan offered India a meeting of Jadhav with his wife on humanitarian grounds. Pakistan then said that it will allow the wife and mother of alleged Kulbhushan Jadhav to meet him on humanitarian grounds on 25th December. It allowed them to be accompanied by an Indian embassy official as requested by New Delhi. In between, Pakistan filed a counter memorial before the ICJ against India's plea to prevent execution of Jadhav. Then, on December 25, 2017, the wife and the mother of Kulbhushan Jadhav met him for 40 minutes at the Foreign Office in Islamabad, while Deputy Indian High Commissioner and Pakistani officials listened in on the conversation outside. The International Court of Justice fixed April 17 and July 17, 2018 as deadlines for India and Pakistan respectively for filing of the written pleadings in the Kulbhushan Jadhav case. April 17, 2018, India filed its second round of pleadings to the ICJ at The Hague. July 17, 2018, Pakistan submitted a 400-page reply in the International Court of Justice as a rejoinder to the India's last reply on April 17. November 20, 2018, then External Affairs Minister Sushma Swaraj said that India had sought diplomatic access to Kulbhushan Jadhav. February 18, 2019, a 4-day-long public hearing was held in Kulbhushan Jadhav case at the International Court of Justice. Harish Salve represented India and Kulbhushan Jadhav at the hearing. In the hearing, India called Jadhav's sentencing a breach of Vienna Convention, while Pakistan insisted that Jadhav was an Indian spy. Last month on July 17th, the International Court of Justice ordered that Pakistan must undertake an effective review and reconsideration of Jadhav's conviction and sentencing. The ICJ asked Pakistan to grant consular access to him without delay. Bureau Report, Rajya Sabha TV.
Various disputes between nations have ended up in the International Court of Justice. The first case between United Kingdom versus Albania entered the general list of the court and was submitted on 22nd May 1947. India has been involved in cases at the ICJ on 6 occasions, including the present one about Kulbhushan Jadhav. On 4 of the 6 occasions, Pakistan was the opposing party.
Before Kulbhushan Jadhav, Sarabjit Singh, a farmer from Punjab, was implicated on charges of terrorism after he inadvertently crossed over to Pakistan on 30th August 1990. A local court sentenced him to death on charges of engineering bombings in Lahore and Faisalabad in 1991. Pakistan's Supreme Court upheld the death sentence in a fast-track trial was flawed on several counts. Sarabjit Singh was tortured to extract a confession without any material evidence to link him to the blasts, while India maintained that Sarabjit was not a spy and his was just a case of mistaken identity. It never approached the ICJ, like the Modi government did in the Jadhav matter. On 2nd May 2013, Pakistan announced that Sarabjit had succumbed to the injuries. Among other cases at the ICJ include the United Kingdom versus Albania case submitted on 22nd May 1947. It was the first case that entered the general list of the court. There was also the Iran hostage crisis that involved a diplomatic standoff between Iran and the United States. 52 American diplomats and citizens were held hostages for 444 days from November 4, 1979 till January 20, 1981, after Iranian college students who supported the Iran Revolution took over the US Embassy in Tehran. It was the longest ever hostage crisis. At America's request, the court said there was nothing more fundamental than the inviolability of the diplomatic envoys and embassies. It indicated provisional measures to ensure immediate restoration of the embassy premises to America and release of the hostages. In the Republic of Nicaragua versus the United States of America in 1986, the ICJ ruled in favor of Nicaragua and awarded reparations. The ICJ said US violated international law by supporting the Contras in their rebellion against the Nicaraguan government. The United States avoided the proceedings and claimed the court had no jurisdiction to hear the case. On 20th December 2018, the UN General Assembly passed a need for immediate compliance resolution. It concerned the 2004 Vienna Case regarding the failure of the United States to notify Mexican consular officers of the arrest of 54 Mexican nationals on murder charges. The International Court of Justice ordered the US to comply with the Vienna Convention and provide proper remedies to the accused who were not provided consular services. Many of those convicted have recently been executed by the US that prompted the request for his UN resolution. India was involved in 6 cases at the ICJ, including Kulbhushan Jadhav. 4 had Pakistan as the opposite party. In 1955, Portugal claimed right of passage through India to ensure communications between Daman and its enclaved territories of Dadra and Nagar Haveli. India contended Portuguese authority ended in Dadra in 1954. The ICJ ruled that India had not acted contrary to its obligations. In 1971, India said that the Council of the International Civil Aviation Organization had no jurisdiction on a complaint by Pakistan. In 1972, the ICJ rejected Pakistan's objection that the ICJ had no jurisdiction to entertain India's plea. It also held that ICAO competent to entertain the complaint made to it by Pakistan. In 1973, Pakistan sought proceedings against India on charges of genocide against 195 Pakistani nationals, prisoners of war or civilian internees in Indian custody. The case ended after both India and Pakistan came to an agreement on the issue. In 1999, Pakistan entered a dispute on the destruction of a Pakistani aircraft by India. Pakistan said that the ICJ had jurisdiction in the issue, but the ICJ concluded that it had no jurisdiction to entertain the application filed by Pakistan. In 2014, the Republic of Marshall Islands instituted proceedings against all nuclear weapon states, contending breach of customary law obligations on nuclear disarmament. India said the ICJ had no jurisdiction in the case. The court accepted it that it cannot proceed to the merits of the case because of lack of jurisdiction. Wing Commander Abhinandan Vardhaman's release from Pakistan's custody in February this year rekindled cases of families of Indian prisoners of war still languishing in various Pakistani jails. There are at least 54 Indian prisoners of war, some of them seriously ill, and some who have lost their mental balance or even died under mysterious circumstances. But faulty details provided by Pakistani authorities during the 1971 Indo-Pak War, when these soldiers were taken as prisoners of war, are responsible for their illegal detention by Pakistan. Bureau Report, Rajya Sabha TV.
And that's it from us today in In-Depth. We'll be back same time on Monday with a focus on some other subject. In case you missed the television broadcast, you can also watch our program online on YouTube, the link for which is given below. Suggestions and feedback about the program are also welcome. Thank you for your time.